Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name is Aaron Asidu Ng. Today we are presenting live from the Jataba Media Network studios here in Bawi, Accra. In our last episode, we looked at coup d'etats, but today we are looking at constitutionalism. Constitutionalism. I would like you to subscribe, like, and share, and pay attention because this is the backbone of constitutional law. And so I'm taking my time to explain what the concept of constitutionalism is. Today, our table of content, or what we will be doing, would be first looking at the meaning and nature of constitutionalism. I'll move ahead to look at the means or mechanisms for ensuring constitutionalism, and then proceed to look at the core elements of constitutionalism and end on the expression of constitutionalism in making the interpretation and application of law and policy. So let's zoom in. Let's look at the meaning and nature of constitutionalism. You recall the meaning of what a constitution is. I mentioned to you that a constitution does two things. It creates the states. The Article 1 Clause 1 of the Constitution 1992 goes ahead to create the arms of government, the legislature, the executive, and the judiciary. I want us to focus on this man, John Locke's theory of social contracts. This is what he says. He stated that the people give up some of their natural rights to form governments that protect their lives, liberty, and property. In exchange, the government is responsible for providing them security and prosperity. I'm sure that when you are going to vote, mostly you look at whether the government is actually protecting you or ensuring that your economic well-being is far better or far better than as they took over from government. And so this is what John Locke is saying. He says that the states or the people give up some of their natural rights to form government that protect their lives, liberty, and property. And in exchange, the government is responsible for providing security and prosperity. So the government is here, the people are here. The government is here and the people are here. So if the people are here and the government is on my left, my right is the people, and my left happens to be the state or the government. The government. So the state here, that is the people, and the government on my left. So if these the people are giving up their natural rights for the state to protect, or for the state to be responsible for giving them security and also ensuring that they prosper. If the state abuses their power or does not do or does not provide them the security and prosperity, let me not forget, Lord Acton once said, power corrupts and absolute power corrupts absolutely. So those in government becomes so corrupt with power and do not provide the security and prosperity these people are demanding, there is a likelihood that these people will oust the people in government. And if they are ousting them, they either vote them out or most of the times there are coup d'etat. I believe that you just check some countries, when people are fed up with the government to the highest point, they do not even wait for elections. They go ahead and topple the government through coup d'etat, as we learned in our other episode. The framers of the 1992 Constitution knows that when the people in government abuses their power, there is that likelihood that there will be coup d'etat. And so they have brought some stopgap measures into the Constitution so that it will check those in government in order for them not to abuse their power, to keep a balance between the people and those in government. And these stopgap measures the framers of the Constitution have introduced are those elements in the Constitution that seeks to limit public power. And so when we mention constitutionalism, and those elements are constitutionalism, those elements we are talking about is what we mean by constitutionalism. So when we talk of constitutionalism, we are looking at the elements in the Constitution that seeks to limit the exercise of public power. So the executive, the legislature, and the judiciary are exercising public power, and constitutionalism are the elements in the constitution that seeks to limit those public power that has been distributed to these three arms of government. That is basically constitutionalism. Constitutionalism itself thrives on mechanisms, or these limitations has actually been grouped into three mechanisms, and they are the institutional limitation, 2 substantive limitation, and 3 procedural limitation. It follows no order, so you can just mention it either from procedural limitation to institutional or substantive. And so let's look at this institutional limitation. With regards to the institutional limitation, when you pick the Constitution 1992, clearly Article 58(1), Article 93(2), and Article 125 Clause 3 has respectively given executive authority to the president, or vested it in the president, and legislative authority to the legislature or parliament, and also the judicial authority or judicial power to the judiciary. So it means that institutionally these three arms of government have been limited. The executive exercises executive authority. Parliament shouldn't be exercising executive authority. Parliament should be exercising legislative authority. In that same vein, the executive cannot be making laws or be exercising legislative authority. And also judicial authority remains with the judiciary and no other institution. And so institutionally, these three arms of government are limited. The next limitation I'm going to talk about, or mechanism, is the procedural limitation. And I'll give you an example. Let's look at Article 106 or 106 of the Constitution 1992. Article 106 of the Constitution 1992 tells you the process of making laws in Ghana. So as the legislature is responsible to exercise legislative authority, they are limited in the way they would even pass laws. Must go through first reading, second reading, and all those things, consideration stage, amongst others. There is a laid down procedure in Article 106 of the Constitution 1992. So procedurally, they are limited. Let's refer to the case of Republic versus Director of Prisons ex parte Salifa. Mostly we refer to it as Salifa number 1. In this case, during the National Liberation Council time, the NLC time, they had stated that before they term something as a decree, they must number it. However, the decree that sought to detain Salifa was not numbered. And so when Salifa was detained, his parents or his father went to the court to actually, on the order of habeas corpus, which simply means that produce the body, and stating that since the NLC had themselves stated that their decrees would be numbered, this decree that sought to detain his son was not numbered, and as such, that decree cannot be declared or deemed as a decree properly so called. The court reasoned and agreed with the arguments of the father of Salifa. Remember that a child or someone below 18 years does not have the capacity to maintain an action, and as such, that person will see through either his parent or his guardian ad litem. So in this case, Salifa was seeing through his father, his father, who actually went to court, asking the court to grant the order of habeas corpus. And so the court stated that since you yourself as NLC have stated that the procedure in making your decree is by numbering it, and in this present instance, you did not number it, what the court stated that decree cannot be deemed as a decree properly so called. The last limitation I'll be talking about is the substantive limitation. Substantively, you are limited. And so let's look at Article 3, Clause 1 of the Constitution. If you've been following the Law Lab update on Facebook, in one of the days we mentioned that, or we actually updated Article 3.1 of the Constitution 1992, and it reads, Parliament shall have no power to enact a law establishing one-party state. So Parliament has been substantively limited in passing any law to establish a one-party state. So Parliament cannot do that. That is a substantive limitation. And now let's look at the case of S Party Bannerman. S Party Bannerman. What happened in S Party Bannerman? In S Party Bannerman, the NLC had actually set out a committee for the committee to go and investigate the National Fishing Corporation or the State Fishing Corporation, where Bannerman was working as, I think, a marketing manager or a line manager in one of the departments over there. The commission finished their work and stated that, well, there has been some allegations leveled against Bannerman. They did not call Bannerman for Bannerman to even explain himself, but they went ahead to summarily dismiss him. And Bannerman brought an action on ex parte motion, stating, among other things, the breach of natural justice. That is, one, he wasn't given a fair hearing, amongst others. And also he stated that the committee or the commission that came to the State Fishing Corporation to be investigating them did not have the powers to even summarily dismiss him. And so the court reasoned that, yes, the NLC had given a terms of reference to the committee or the commission that go and investigate. That is all. So substantively, they are limited to only investigating. They have no powers or power to go ahead to dismiss anyone from the State Fishing Corporation. So clearly, the committee that was set out by the NLC was substantively limited. Having known all these three mechanisms of constitutionalism, that is a means of limiting public power, we should also know that constitutionalism thrives on elements. It thrives on elements. So there are these elements within our constitution or in our constitution that seeks to limit public power. Some of these elements are rule of law, separation of powers, human rights, judicial review, checks and balances, amongst others. I'll take my time in subsequent video. In our next video, we'll be dealing with rule of law and explain these elements one after the other for us to understand. Today, basically, we've looked at constitutionalism, and we started by looking at John Locke's theory on social contracts, where John Locke is saying that the people give out some of their natural rights for the state to protect their lives, property, amongst others, and they are expecting the state to also give them security and also ensure that they become prosperous. And so Lord Acton has also reminded us of the fact that power corrupts and absolute power corrupts absolutely. So where the state's people in power become so corrupt, there is that likelihood that the people will topple power, which might lead to coup d'etat, amongst others. However, the framers of our constitution thought of it that they do not actually want coup d'etat, and so they are bringing some stopgap measures in our constitution to prevent a possible coup. And these stopgap measures are the elements in the constitution that seeks to limit public power, and these elements are what we refer to as constitutionalism. Now, having known these elements, the next thing we looked at is to look at the means or mechanisms for ensuring constitutionalism, where we mentioned the institutionalism type of limitation, procedural limitation, and substantive limitation. We moved ahead to look at some of the core elements of constitutionalism. These elements ensure that public powers are limited. So in our next episode, when we are looking at rule of law, you see that rule of law in its essence or per its effect limits public power. Another thing I want us to consider before we bring this session to an end is the application of constitutionalism to law and policy. And I want you to get this. Constitutionalism, broadly speaking, therefore, is that concept or idea which will help us draw a line between positive element of having a constitution and the normative element of having a purpose for having a constitution. And I remember my lecturer, Dr. Justice Sheremsai Esquire, when he was actually taking us through constitutionalism, and he mentioned this. I'm taking it again. It is constitutionalism is helping us to draw a line between the positive element of having a constitution and the normative element of having a purpose for having a constitution, I quizzed him that I don't understand this. I'm sure most of you are even asking yourself, what does this mean? There are constitutions that do not have elements within them that limit public power. So those constitutions are constitutions without constitutionalism. But those constitutions that has elements within them that limit public power, like that of the Constitution 1992, are the type of constitutions that gives purpose of having a constitution. The limitation gives you a purpose of having it in the sense that when you have elements within the constitution that limit public power, then you get to know that there is a balance within the society, and those who in government, when they act within the limits and the borders of the constitution, they are likely not going to abuse public power. And so basically that is it with the concept of constitutionalism. Dear one, please like, share, comment, and subscribe to the Law Lab for other exciting content. As I mentioned early on, in our next episode, we will be treating rule of law as an element of constitutionalism, ensuring the limitation of public power. Thank you very much. And as I've always been saying, do not leave all your matters to God. Take some to your lawyer, as your lawyer too would have to eat. Thank you.